Hey, look, the other day I went live here on YouTube, but one of the individuals who was watching the live stream had notified me during the course of the live stream that he could not hear what I was saying. So, in response to that, I checked the status of the live stream from my end and found that everything was kosher. However, after the live stream had ended, out of curiosity, I actually replayed back the live stream that I conducted and found that one of the viewers was correct when he said that he could not hear anything. So I don't know what the cause of that particular problem was. So now I am back, hoping that the situation with YouTube has resolved itself. Before I begin, though, I would like for someone to come in to inform me uh, with regards to them being able to hear me before I begin. Uh, Basically, I'm going to reiterate what it is that I said before in perhaps greater detail than what I initially did because of me not being subjected to time constraints at the moment. Typically, when I conduct these live streams or when I have in recent times, it was before going to work, primarily in the daytime. So I decided to come here today before it got too late for many of us uh, to recap what it is that I was speaking about the other day. And for those of you who are unfamiliar with that particular live stream, I actually deleted it because I didn't feel any need to have it on when people could not hear what it is that I was speaking about. But if everybody can hear me now, the basis of that particular live stream revolved around the right that all Americans have with regards to exercising the civil liberty to keep and bear arms under the Second Amendment to the Bill of Rights. And when I say all Americans, I mean exactly that. All Americans incorporates every citizen of the United States, whether that citizen has been previously convicted of a felony or misdemeanor offense. It doesn't matter if those offenses, with regards to the conviction, were violent or nonviolent. The Second Amendment right to keep and bear arms was designed to be exercised by all Americans. So, with that being said, I just know that someone had came into the live stream, and like I said earlier, I wanted to make sure that you all can hear me. Is my volume sound up to the point to where um, the viewers can actually hear what it is that I'm saying or what it is that I intend to say during the course of this particular live stream? I don't know who you are that's watching right now, but if you can hear me, could you type it in the chat? Anyone watching the live stream, if you can hear me, could you type in the chat? I would appreciate it if you did. If you cannot hear me, you can also type that into the chat as well. I appreciate that, Chloe. Chloe Hayes, 6364. I appreciate that. Okay. Being that I can actually be heard this time, I wanted to go into the right that we all have to keep and bear arms under the Second Amendment. Okay, appreciate it. Oh yeah, I appreciate that, Ace. One of the things that I want you all to know about me, how you doing, Ariel, is that I have studied American jurisprudence for over 20 years of my life. What's up, boss boy? And before studying law, I, like many other Americans, to include other citizens who reside in other countries, have been misled by those in civil service with regards to the freedoms that we have, the very freedoms in which we have elected or appointed those particular individuals to protect and defend under the Constitution from enemies both foreign and, yes, domestic. I appreciate that area. I hope you have a nice day as well. Now, what I learned during the course of my legal studies, y'all, is that the Second Amendment to the Bill of Rights specifically says what it means and means what it says. And for those of you who are unfamiliar with that, okay, good night, Aria. I hope I pronounced your name correctly. But for those of you who are unfamiliar with the Second Amendment to the Bill of Rights, it specifically says, and I quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. Now, in order to fully understand what the Second Amendment to the Bill of Rights entails, I want to direct your attention to the definition of keep and bear, to include arm, weapons, infringed. Now, for those of you who actually have a dictionary at hand, I'm reading from the 10th edition Merriam-Webster's Collegiate Dictionary, which on page 637 defines the word keep as, and I quote, to refrain from revealing, end quote. Now, we know that if a person refrains from revealing something, that individual is actually concealing the thing that they are refraining from revealing, right? So when the Second Amendment specifically says that the right of the people to keep arms, that specifically entails that we all have a right to conceal the firearms that we choose to carry for our own personal protection. So being that the Bill of Rights authorizes that particular action to be exercised by every individual, how you doing, Casey? That specifically means that we don't have to pay some politician or another civil servant money to get their permission to exercise our right to conceal the firearms that we choose to own. Okay? Now, moving back to the Second Amendment. It also says that we have a right to bear arms, right? Now, the definition of bear in reading from the 10th edition Merriam-Webster's Collegiate Dictionary defines the word bear on page 99 as, and I quote, to carry or possess weapons, end quote. Now, being that that particular definition does not indicate that we have a right to refrain from revealing the firearms that we choose to carry, we can surmise from that particular definition that the Second Amendment also enables us to openly carry the weapons that we choose to own, specifically firearms, because they are the primary weapon utilized by Americans in this current day and age for the purpose of self-defense or self-preservation for that matter, because many people hunt for their own food, and we know sustenance, which we get from food, preserves life. So yes, self-preservation. Okay, so now we know that the Second Amendment to the Bill of Rights not only authorizes us free of charge to conceal the firearms or other weapons that we choose to own, but also to openly carry those weapons or firearms that we choose to have in our possession. Now, moving on to the word arm. Under the same dictionary on page 62, arm is defined as, and I quote, weapons, end quote. Okay, so weapons can be anything, right? So we go to the definition of weapon as defined again in the 10th edition Merriam-Webster's Collegiate Dictionary on page 1334, which states, and I quote, something as a club, knife, or gun used to injure, defeat, or destroy, end quote. So we know arm is associated with weapon, and the definition of weapon is something such as a club, knife, or gun used to injure, defeat, or destroy. Now, what are firearms used for here in the United States of America? Surely they are used for the purpose of self-defense. But in defending ourselves, or one defending his or herself, one has to more than likely injure a person in order to defeat that individual. And in order to defeat that individual or individuals, we may have to destroy, right? And when it says gun, weapon, it doesn't define which weapon, as made evident from the definition, which entails that not only do we have a right to have semi-automatic firearms, but also fully automatic firearms, because fully automatic firearms also can be used to injure, defeat, or destroy, right? Grenade launchers can be utilized to ensure the same purpose. Rocket launchers, the same. So when the Second Amendment specifically said arms, it didn't differentiate between the weapons that we Americans could actually legally possess under the Second Amendment to the Bill of Rights. Okay? Now, last but not least, the Second Amendment says that the right to keep and bear arms shall not be infringed. So in order to understand that specific amendment even more so than what we do now, I want to direct your attention to the definition of infringed. And that definition comes from, yet again, the 10th edition Merriam-Webster's Collegiate Dictionary on page 599, which states, and I quote, to encroach upon in a way that violates law or the rights of another, end quote. So when the Second Amendment specifically says that the right to arms, whether that be fully automatic weapons, sawed-off shotguns, revolvers, doesn't matter what year they were manufactured, the speed of fire that they have, the capacity of ammunition that they hold, doesn't matter. Arms is arms. So when it said that, when members of Congress, to include state legislators, enact laws such as the Gun Control Act, the National Firearms Act, amongst other federal statutes, to include state statutes such as the Felony Firearms Act here in the state of North Carolina, those legislators, both federal and state, were in violation of the supreme law of the land when they ignored, through encroaching upon, our right to keep and bear arms under the Second Amendment, which makes them the criminals, right? Because the Second Amendment to the Bill of Rights, that is the permit that we need. The only permit that we need, because When you look up the definition of permit in the dictionary, the definition of permit is a document that authorizes someone to do something. So, what is the Bill of Rights? The Bill of Rights is a document. The Second Amendment to the Bill of Rights is what authorizes us under that document to keep and bear arms, a right that that specific amendment declares shall not be infringed, which makes every legislator, every judge, every law enforcement officer, every military officer, every legislator, every civilian who has ignored the right of everyone in this country to keep and bear arms have, in essence, violated the supreme law of the land. And yes, we know that the Second Amendment to the Bill of Rights is associated with the supreme law of the land because under Article 6, governing the Constitution for the United States of America, it specifically says that the laws ratified under the United States, whether that be treaties or otherwise, are considered to be the supreme law of the land. The Bill of Rights was added in conjunction with the Constitution because the Founding Fathers were not too kosher with enforcing a Constitution without having some written guarantees that those in civil service would not become tyrannical to the extent that King George III did, which led to the Revolutionary War of 1775 at that particular stage after Americans won their freedom. Hence, we know that to be a part of the Declaration of Independence, right? So, with that being said, it is evidently clear that every act of gun control in America, in spite of what the judges in the Supreme Court says, or any other person for that matter, is unconstitutional. And unconstitutional technically means illegal, unlawful. So if a law is unlawful, according to the Supreme Court judges in the case of Marbury versus Madison, written in the year of 1803, still good law today, based upon what they say, any law that is ratified that does not conform with the Constitution and any other document associated with it is null and void, meaning it cannot be enforced by no one. And if gun control laws cannot be enforced, that means that they do not apply, that they cannot be the basis of imprisonment. So if they cannot be a basis of imprisonment, why the heck are so many men and women currently confined in federal and state penal institutions under a law that has been declared unconstitutional on many occasions in the past? I'm going to tell you all why. Because we, the people in general, have neglected our responsibility and obligation to ensure that those in civil service were held accountable when they overstepped their bounds through encroaching upon the very freedoms in which we place them in those positions of public trust to protect and defend under the Constitution from, and I will reiterate, enemies both foreign and domestic. That's the problem. A big problem. And for those of you who need legal authority, such as judicial precedent, to get the courage that you need to fully understand and to adhere to what it is that I have told you thus far, I'm going to take you all to the case of United States versus Cruikshank. I found out about that case many years ago, y'all. within, I think, 12 years of my legal study, that's when I came across this case. And keep in mind, this case been out on the books, good law, since 1876. And the citation number for that case is 92 US 542 23 LED 588, 1876. On page 553 to that specific judicial decision, Chief Justice Morrison Remick Waite, in writing for the majority, stated, and I quote, "The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. This is one of the amendments that has no other effect than to restrict the powers of the national government." End quote. Now, who is the national government? I'm going to tell you all who the national government is. The national government consists of individuals associated with the legislative, executive, and judicial branches of the United States of America, such as the President for the United States, the United States Congress, and of course, the United States Supreme Court judges, to include lower federal court judges under the Circuit Court of Appeals or the United States District Court. Those are the individuals who consist of the national government. So, after reading that particular decision, I got to thinking to myself, y'all, with this decision being on the books, why were so many individuals, or why have so many individuals been imprisoned for exercising the Second Amendment liberty to keep and bear arms under the Bill of Rights, when the judges of the Supreme Court stated in specific detail that no one within the United States government has the authority to enact legislation that restricts our access to firearms through gun control, in addition to no one within the national government being in a position, such as law enforcement personnel, to enforce those type of laws, let alone allow the judges to apply those specific statutory provisions that were unconstitutionally ratified, when they have no legal authority under the Constitution to do that. Now, you will find in other Supreme Court cases, and I can actually mention those with clarity, of course, that the reason behind what the judges said in this case as it pertains to members of Congress was that they were under the impression, and rightfully so, that the Second Amendment to the Bill of Rights predated the Constitution for the United States. And because the Constitution is the document that sets out the privileged authority that we, the people, through our ancestors, of course, have given those in civil service the authority to do certain things. And because the right to keep and bear arms predated that particular instrument, our right to keep and bear arms is not predicated upon the ratification of the Constitution because, like I said earlier, it predated that particular document. So, because it predated the ratification of the Constitution, which gives those in civil service the privileged authority that we have given them, it doesn't enable them the authority under the Constitution, in spite of what they have been spewing from their lying mouths, the authority to enact firearm legislation. Now, of course, through my legal studies, they give the same freaking bogus excuses, y'all, as to why they would encroach upon their freedom. And one of those excuses was the necessary and proper clause. Let me tell you a little something. Let me tell you all something. And I hope against hope that some civil servant comes across this particular YouTube video. But I'm going to tell everybody this: necessary and proper clause of the Constitution. It is neither proper nor necessary for those in civil service employed as members of the United States Congress to enact legislation to restrict our access to firearms through gun control measures when it comes to ensuring that we are in a position to protect ourselves from physical attacks by lawless individuals or acts of tyranny that could and has been perpetrated against the American people by those in civil service. How is that proper? To disarm individuals, which puts them in a position to where they are unable to fully protect themselves. And how the heck is that necessary to stop criminal behavior when criminal-minded individuals come at individuals such as myself and you all with ill intent, and we have no adequate means such as the possession of a firearm to protect ourselves with? So how is that proper and necessary for our personal protection? That is what we need to ask ourselves. And that's a question that those dummies in civil service cannot answer. Trust me, I presented it to them on various occasions. No response, which lets me know that I'm on the right path. Because like the judges say in the case of United States versus Grace, if I'm not mistaken, no. When somebody is silent in responding to a specific inquiry, the judges are under the impression that they are in agreement with what was said. Now, I don't agree with that, but since judges claim that, we're going to utilize that content from that specific judicial decision to benefit our interests under the circumstances. Okay? Now, I will say this. In the case of United States versus Cruikshank, right after that portion of the decision in which I read to you all, the judges did say that because they were under the erroneous presumption that the Bill of Rights did not apply to state legislators or governors, to include state court judges and state Supreme Court judges, that they were the only ones, or should I say specifically, state legislators were the only ones who can actually legislate acts of gun control to restrict citizens from having guns. Now, that was preposterous in its own right. I didn't have to dwell deep into legal research to understand that, because my thing is this, y'all. Before the Constitution was ratified, before the 13 colonies became the United States of America, that meant that people within each colony or each state had to agree with the Constitution being ratified. And because they all agreed, which made it the Constitution for the United States of America, because these people in specific states united as one in agreement with the Constitution being ratified, that means that everyone was in agreement with the Constitution, which makes every one of those individuals bound by the contents of that specific document. So when the Supreme Court judges say stupid stuff like that and expect us just to run with it because of the position that they're in, the position in which we have allowed them to have and to keep, of course, it was outlandish to me. See, I don't agree with every judicial decision that's been ratified, because some of these judicial decisions are outrageous. So when I look at a judicial decision, I look at judicial decisions that specifically coincide with, let's say, in this particular case, the Second Amendment to the Bill of Rights, or any other liberty for that matter, but specifically the Second Amendment, because that is the basis for the conversation in which I have initiated this live stream for. Okay. However, fast forward and over 100 years later, in the case of McDonald versus City of Chicago, citation number 561, US 742, 177 LED, 2D 894, 130 SCT 320, 2010. Now, this particular judicial decision was written by Associate Justice Samuel A. Alito. And on page 750 to that specific judicial decision, Mr. Alito said, and I quote, "We have previously held that most of the provisions of the Bill of Rights apply with full force to both the federal government and the states. Applying the standard that is well established in our case law, we hold that the Second Amendment right is fully applicable to the states," end quote. Now, when the McDonald decision came out, what that case essentially did was overrule the portion of the Cruikshank decision of which I read to you all earlier with regards to only state legislators being able to enact a firearm legislation. See, the McDonald decision eradicated that. So it overruled in part that portion of the Cruikshank decision, which means that the Cruikshank decision was made to be retroactive to state legislators, governors, and judges. Okay, so what that particular case in the Cruikshank decision said about members of Congress not being permitted to enact legislation that restricts our access to firearms, that particular statement also applied after the McDonald decision was rendered to state legislators as well. And I'm gonna put a little clarity on that, right? See, when I studied law, I noticed that it was a few prisoners that utilized the Cruikshank decision as a precedent in order to have the conviction of possession of a firearm by a felon overturned. Okay, now what I noticed about every case that I read back then, I don't know what's going on there, but I'm under the impression, or I can surmise based upon what it is that I know through experience, that a lot of prisoners are still unfamiliar with those particular cases, specifically the Cruikshank decision, of which I made reference to earlier. So technically, they're still being incarcerated under a freaking offense that they shouldn't have been in prison for. But anyway, these cases were filed by state prisoners in the state court system. Now, what these prisoners would say, they would say that state legislators didn't have the authority to enact legislation based upon that specific judicial decision. But from experience, many prisoners do not read the fine print when it comes to judicial opinions or statutory provisions. So, of course, the judges in the state court system concluded that that particular case, the Cruikshank decision, only applied to federal prisoners and not state prisoners, which if we looked at the decision, that's what it said, even though I disagree with that. But that's what it said. But no federal prisoner, to my knowledge, has utilized that case to the extent that I believe it should have been utilized. All right? In order to get them out of prison on account of essentially exercising a freedom, the freedom that they have to keep and bear arms under the supreme law of the land. And I tell people this, especially when I used to teach legal research, and I still tell people this to this very day. We all have freedoms, right? And the Second Amendment right to keep and bear arms is one of them. And that specific freedom is protected by the supreme law of the land, known as the Bill of Rights, which is synonymous with the Constitution for the United States of America. So if The Second Amendment to the Bill of Rights is protected by law, it's authorized by law, was enacted by law. Anyone who exercises that specific freedom are in conformity with the law, which makes those individuals, to include myself and you all, law abiding citizens. Anyone who would disregard that specific freedom, the freedom that we have to keep and bear arms under the supreme law of the land, are lawbreakers, which makes those particular individuals criminals, or the most popular term that is oftentimes used, felons. You see, one cannot be considered a criminal for doing what the law authorizes that individual to do. But when one disregards the law and does things that the law does not authorize that individual to do, that is what makes those particular individuals criminals. So, for all of my brothers and sisters that have been incarcerated in federal and state penal institutions for simply exercising your Second Amendment liberty to keep and bear arms under the Bill of Rights, you were there illegally. You were there not because you violated the law. You were there for exercising the freedom that you have that is protected under the supreme law of the land, which makes everyone complicit in your imprisonment criminals. On more than one front, I might add. And that is ridiculous. And then when we go to District of Columbia versus Heller, citation number 554 US 570 171 LED 2D 637 128 SCT 2783 2008, where Associate Justice Antonis Scalia stated on page 581 that, and I quote, "We start, therefore, with a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans," end quote. Now, you see in that decision where it didn't say that the Second Amendment right is exercised individually and belongs to all Americans, unless that American has been convicted of a felony or misdemeanor offense. See, it doesn't say that. It says all Americans. And last I checked, even individuals that are incarcerated who are American citizens in a state and federal penal institution or penal institution are still citizens of this country, which means that the Second Amendment right also applies to them. And when I was telling you all about the Cruikshank decision and the McDonald decision, how the McDonald decision made the right that we have to keep and bear arms applicable to not only members of Congress, but also state legislators and other civil servants as well, that can be found in the case of Katana versus Massachusetts, citation number 577 US 411 194 LED 2D 99 136 SCT 1027 2016. And that decision was or should I say that this was the portion of the decision that I'm about to read to you all was written by Associate Justice Samuel A. Alito Jr., who was joined by Associate Justice Clarence Thomas. They were concurring in the judgment, and they were also citing collected cases in support of the statement that they made. And that statement was, and I quote, "It is settled that the Second Amendment protects an individual right to keep and bear arms that applies against both the federal government and the states," end quote. You see, the same thing that applied to members of Congress in the Cruikshank decision after the McDonald decision was handed down automatically applied to state legislators. Now, we all know how the process with regards to the three branches or three co-equal branches of the American government operates. And for those of you who do not know, let me enlighten you. How the government works with regards to how laws are enacted and enforced, or should I say enforced. First, a legislator has to put certain content in a bill. And once that content is placed in a bill, members of a legislative organization, whether federal or state, they bring it to the floor for the majority of members of the House of Representatives or the House of Senate to vote upon. Now, once they vote and the individual who put the bill on the floor obtains the majority vote, then that specific bill or the contents within that bill becomes what they call law. All right? Now, we all know that once it goes through the House of Representatives, it is passed over to the United States House of Senate or the House of Senate, depending on whether we're talking about federal or state. And they too make a decision. And let's say the majority of members of the House of Senate agrees with that particular bill becoming law. It goes to the president or a governor for signature. Now, more oftentimes than not, the governor or the president will sign off on it, right? So it becomes law. But there have been cases where the governor or president didn't want to sign off on a particular law for a specific reason, and the law went back, or should I say the bill went back, to members of the legislative branch for an additional vote, a majority vote. Now, once that happens and the majority of the legislators approve the bill, it becomes law in spite of the governor or president not wanting to sign a particular bill to become law. All right. So when a bill becomes law, that's what authorizes law enforcement officers to arrest individuals for breaking or breaching the law. And once an individual is arrested for breaching or violating the law, they are taken through what they call the criminal justice system. I like to say the judicial system because there's really nothing truly just about it from what I've seen. In spite of what the propaganda they have put out for us to soak in, which many of us unfortunately have done so. And that's when a judge applies the law as it was written that was enforced by law enforcement personnel. Now, the problem is when it comes to judges applying the law, judges have shied away from that. When they started adding on their 2 cents to a freaking law that has already been ratified. Okay? That's something I don't agree with. For instance, the Civil Rights Act specifically says that if anyone violates your freedom, they ought to be held accountable. Now, when they say anyone, they're talking about law enforcement personnel specifically. So what happens when law enforcement personnel have abused a civilian through excessive force or unnecessary force, which cause one to meet his or her untimely demise, or cause someone to have been wrongfully accused and imprisoned after a conviction for many years on account of the abusive practices perpetrated against people by law enforcement personnel. What has been happening, or what has happened for many years now that is continuing to happen this very day, is that judges have created what they call qualified immunity, right? Now, if you look at the Constitution, there's no such thing as qualified immunity. The only time it mentions immunity in the Constitution is when it comes to the president for the United States of America. And that only involves civil cases. And that is so because if a president makes a decision and that decision is wrong, The Constitution doesn't permit any one of us to penalize that individual for simply making a decision in which that person presumably thought was best for everybody within the country. All right? I can agree with that. I will give them that. But it doesn't say that a president is immune from criminal prosecution. But when these judges in the Supreme Court for the United States of America have created this qualified immunity, this sovereign immunity, this judicial immunity, which enables them to violate the law with impunity at our expense, to our detriment. I do not freaking agree with that crap. I don't. I never will. In spite of what they say. And that leads me to the point of me making, many times in the past when I spoke to people, the importance of each and every last one of us becoming familiar with law and politics. Because without politics, there will be no law. Without law, there will be no politics. Because politicians make law, right? You can't have one without the other. And many people claim that they don't want to get involved in politics. But for those of you who think that, I want to encourage you to change that particular thought process that you have. Because if you don't know anything about law and politics, how are you going to vote for a specific man or woman to take a specific position of public trust to represent the interests of the people to the best of their ability under the Constitution, in which they have taken an oath to protect and defend from enemies, both foreign and domestic? You see, when we don't know enough about politics, we will never be in a position to determine if those who seek our approval through the electoral process is fit for the job or not. So people will continue to just vote anybody in based upon them liking somebody because that may be their favorite actor or their favorite celebrity. But that is not a reason, y'all, a true reason to put certain people in positions of public trust. And I say that because it brings back memories for me. When I was, how old was I? I was 15 years old, if I'm not mistaken. And let me tell y'all something. One of my favorite movies is The Terminator, which you can surmise that one of my favorite actors was Arnold Schwarzenegger, right? So when Arnold Schwarzenegger was running for governor in California, me being ignorant as I was, thought I was smart, but I was ignorant, I will admit that, I wanted to vote for Arnold Schwarzenegger, even though I was too young to vote according to the constitutional standards that, well, hold up, that's not even, is it in the Constitution? I don't even think no, it's not in the Constitution. It's some statutory provisions that those legislators made in violation of the Constitution. But I would have voted for Arnold Schwarzenegger, y'all. Not because he would have made an excellent governor, but because he was my favorite actor. Popularity won Arnold Schwarzenegger that particular position of public trust. Had nothing to do with how fair Arnold Schwarzenegger was, because what I've seen after he was elected, he wasn't too fair at all. I mean, you can't be fair when individuals are accused of stealing bologna at a grocery store on 3 separate occasions and they get a freaking life sentence in a California prison. That is not freaking fair. And then you get people to kill people and they only get 3 to 5 years. I mean, how much sense does that make? How is that fair? Let's be freaking realistic. I'm going to tell you all something about me. So some of y'all may be wondering about my past. I've always been, I guess you could say, fixated with firearms, right? Because I knew even at an early age that firearms could be used for self-protection. And so I ended up getting me a firearm at the age of, how old was I? I was 15 when I first got a firearm, right? But let me tell you all something. I didn't run around brandishing the gun. I didn't run around robbing people and killing people and all this and that. I basically had the firearm because I love target shooting, y'all, and for self-defense. But I love target shooting. I love to hit targets. To I love to shoot. And I remember one day that my mother, she had contacted my father and told him that I was getting into guns. So my father came to talk to me, y'all. And he was like, Okang, come on, let's go for a walk. So we went to the woods, we sat on a log, and he informed me of why he was there. And what he said was, son, I'm here because your mother has informed me that you have um, associated yourself with firearms. He said, son, I'm going to tell you something. He said, I'm not going to tell you to throw away your firearms. No. He said, I'm not going to tell you to do that. He said, but I will tell you this. Be safe with it. Point it in a direction away from people or certain things that you don't intend to shoot. And he said that if you ever have to utilize a firearm, make sure that it's a true act of self-defense, because you don't want to be pulling a gun on somebody if you didn't intend to use it. That's the advice that my father gave to me. And of course, by him being my father, I listened to him even though I was already on that level, but it made me want to do what's right even more, right? It solidified the beliefs that I already had because my father told me what it is he did. And there was nothing wrong with what my father said. He was absolutely correct. But that's one of the conversations that he and I had, which led me to where I am today with regards to the beliefs that I have, the beliefs and the importance of each and every last one of us exercising that liberty that we have. Because believe it or not, the Second Amendment liberty to keep and bear arms is the liberty that protects all other freedoms that we have, y'all. Now, when we look at what's going on in Palestine right now, Israel, right? I was listening to a few of the Palestinians on TikTok earlier today talking about what needs to be done. Now, one of the things that it seems that people do not understand is that just simply talking and begging for change is not going to cut it. Sometimes physical force, or what they consider violence, is necessary to eliminate the threat to our persons, family, and friends, to include property that we own. Sometimes it is necessary, y'all. I mean, can you imagine if every police officer just talked to a suspect? Put your gun down, put your knife down. And the suspect just kept coming at him with the gun, just kept pulling the trigger. Oh, stop firing your weapon, stop firing your weapon. How many police officers do you think would have been, what they like to say, unalived? How many? You see, physical force is what solves the problem. Now, of course, that is considered to be the last resort um, before that particular action is taken to that extreme. But it becomes necessary, y'all, because people are not going to listen if they do not want to listen. Sometimes you have to put people down in their tracks to protect yourselves and what you believe in. And so they're talking about what's going on over there in Palestine and how everybody just needs to send them money and support them. But who's to say that they are getting the money in which we are sending to these organizations to give to them? Are those members of those organizations ready to put up a firefight in order to ensure that those individuals get the financial support, the resources that those organizations were created to ensure? I'm under the impression that they're not doing that. So if they're not doing that, how do we know that our money is going to the people? How do we know that those in civil service are not confiscating some of that money for their own benefit. We don't know that, y'all, but my point is so many people just talk, talk, talk. Talking is over. Look at what's going on in this country today. People are not getting anywhere by running away from encounters with law enforcement or military personnel. We can't be afraid of civil servants, y'all. Civil servants represent our interests. We are the electorate. Without us, they will never be. So that should let you all know just how much authority each and every last one of us have individually and how much authority that we hold when we come together collectively on a united front. You see, they don't say united we stand, divided we fall for no reason. Those words have a reason, a substantial meaning in this country or across the world for that matter. But so many of us have grown afraid to take the appropriate stance because many of us believe that those in civil service are going to take us down because that's all people have seen during the course of their lifetime. Those in civil service always win and they're always winning. But let me tell you all something, they don't always win. But they're not going to tell you all that. There's some things that I did and won that I haven't yet spoken about here on YouTube, but I have spoken about this on other social media sites, such as Facebook Live, even TikTok, and of course, Bigo Live, fan base, Instagram Live. But people, my point is this. We can't continue to be afraid. And we can't continue to allow those in civil service to warp our minds into believing that because they make a freaking law that we have to adhere to it. That because certain people have been previously convicted of committing certain offenses, that they should no longer be entitled to have a freaking gun. You know, they say that the only right that is not automatically restored, and this is under federal law to include most state laws, specifically here in the state of North Carolina, the only right that's not automatically restored, according to those dummies in civil service, those criminals, those felons, is the right to keep and bear arms. But a person has the right to vote. They have a right to participate on jury duty. But for some reason, these idiots are saying that people do not have an automatic right to have a gun. So what happens when people don't have a gun because they're afraid of being penalized on account of these unconstitutional statutory provisions that those dummies here in the General Assembly of North Carolina have enacted, or to include members of the United States Congress? What happens when that individual don't have a gun and someone breaks into their home, kidnaps their daughter, rapes her, and puts her in a sex trafficking ring? Who gets charged for that? I mean, shouldn't members of Congress be charged for that? Shouldn't police officers and judges be charged for that? Because if they did not do what they did, that would have put the guardian in a better position to defend that daughter. And if that person was in a position to defend that daughter, that means that that daughter wouldn't have never been kidnapped. Hence, she wouldn't have never been raped or put into some sex trafficking ring. But members of Congress always want to shy away from the responsibility of being held their idiotic decisions, their criminal behavior. But y'all, let me tell you all something, and this goes for members of Congress to include every other civil servant in public office. You all have to understand that when self-preservation is on the line, we don't care about any freaking law, rule, regulation, judicial decision that impedes upon the right that we have to protect ourselves. You all cannot just sit up here and tell us that we don't have a right to have a gun, but yet people that's getting out of prison have a right to vote someone into the office of the presidency for the United States of America. An individual that's around all types of freaking armament. And what about Donald Trump? Let's talk about him for a minute. Donald Trump, from what I've seen, has been convicted of over 30 felony offenses. But yet Donald Trump is in the White House. And I'm going to assure you all, even though I haven't seen it, that there are still firearms in the White House. I'm pretty sure that when Donald Trump rides in the Beast, the limousine that they have assigned to him, that limousine is full of armament. Why hasn't Donald Trump been charged and arrested for the possession? Oh no, let me take that back. For the constructive possession of a firearm by a felon. Why? Last I checked, under the Fifth Amendment to the Bill of Rights, everybody is to be treated equally under the law, right? Right? Everybody's to be treated equally under the law. But yet it seems that when civil servants such as Donald Trump get caught in the same mix as another civilian, that those in civil service choose to ignore the law in order to protect Donald Trump while enforcing the law in order to bring a civilian down. Nah, we got to stop allowing that nonsense, people. Have to stop allowing it. But then again, I'm not saying that Donald Trump can't have a gun, because I believe that everybody has a right to have a gun regardless of criminal history or not, because that is what the rights say. That is what the supreme law of the land indicates. But when they sit up here and say that certain people cannot, while they can under the same or similar circumstances, there is where the problem that I have lies. But yeah, as it pertains to people with prior felony or misdemeanor convictions having guns, the answer to that question is an absolute positive. It is a yes. Every one of you with a prior felony or misdemeanor conviction has the right to keep and bear arms under the Second Amendment. Now, in saying that, let me direct your attention to the case of United States versus Whitmire, a citation number 595 F2D 1303, Fifth Circuit, 1979. This particular decision was written by United States Circuit Judge Thomas Gibbs Gee, or G, however he pronounces his name, but it's spelled G-E-E. On page 1319 to that specific judicial decision, Judge Gee said, and I quote, "The essence of the Bill of Rights is the protection even of wrongdoers," end quote. And of course, that particular decision, certiorari was denied in that particular decision. And for those of you who are unfamiliar with what that means, that essentially means that that particular decision was appealed, and a petition for writ of certiorari was filed with the judiciary within the United States Supreme Court. The judges looked at the case, found that there were no violations, so they denied certiorari because they felt that the decision was sound, which makes that decision, even though it was handed down by the appellate court judges of the Fifth Circuit Court of Appeals, it can also be utilized as legal authority in every state in this nation, because it ended with the Supreme Court judges for the United States of America denying certiorari in that case. I learned that in law too, y'all. I'm gonna tell y'all how I learned that though. Because when you study in law, a lot of people were under the impression that, okay, well, that Fifth Circuit case don't apply to the Fourth Circuit because it's up under two separate jurisdictions, right? But I noticed that the judges in the Fourth Circuit were citing other circuit court cases, and I noticed that those cases had certiorari denied on the back of them. So I got to thinking to myself, okay, the judges in the Supreme Court says, in the case of Huddle versus Davis, that their decision is the law of the land, and every judge below them, whether they be in the federal circuit or the district court, is bound by their decisions. So I said, okay, so that is why judges utilize opinions in other circuits as legal authority to support what it is that they are saying in the opinions that they make. So, like I said, under equal protection of the law, if they're using it for that specific purpose, then so too can we. And that is what I started doing, because that is what I found to be the truth. And you also have Supreme Court precedent that supports that specific decision in the Whitmire case as well. Okay, I'm going to get to this, y'all. All right. When I'm talking about the right that we have to keep and bear arms in spite of a felony or misdemeanor conviction, when I say that we all have a right to keep and bear arms because members of Congress, to include state legislators, have no authority under the Constitution to restrict our access to firearms through gun control, that is supported by actual Supreme Court precedent. Okay? I'm letting you all know that now, because they do not want to tell us this. When I say they, I'm talking about members of Congress, state legislators, lawyers that have been assigned or retained to represent our interests in the court of law. They don't tell us this, y'all. I have not yet heard of one attorney, whether on YouTube or elsewhere, especially a lot of the gun tubers on YouTube who claim to have passed the bar exam, who are now lawyers to some extent or another. But to be honest, I feel that if a man or woman has taken a bar exam, passed it, and has never litigated in a court of law, I don't really, to be honest, consider them to be true attorneys, right? Now, of course, yeah, passing the bar, they have what they call the right to practice law. But if a man or woman has not litigated in the court of law, if they have not litigated the case, thinking off the top of their head, going off instinct to make a case and to actually compel others to side with their argument in order to have someone discharged from confinement after being wrongfully accused, they can never really consider themselves to be a true attorney. That's what I say. And you know, the funny thing about me is, y'all, I've never been to law school. Never been. But yet the same resources that they study or had to study in law school, I too had access. So I utilized the access that I had to become aware and more familiar with the law, to the point to where I've had on many occasions in litigating in the court of law. And of course, we do have a right to litigate without a freaking license under Supreme Court precedent. One of the cases is Whitmire versus Arkansas, for those of you who are wondering. Another case is Johnson versus Avery. All right. Those are two Supreme Court precedents that gives non-attorneys the right, the authority. No, let me take that back. They don't give us that authority. They acknowledge the authority that we have to represent other people in the court of law without freaking having a freaking license to practice law. But many judges have asked me, and I'm talking about judges on a federal and state court level, why have I not taken the bar exam and became an attorney at law? And do you all know what my response to those judges was on every occasion? My response was this: I have not taken the bar exam because I do not want to become an attorney at law who's associated with the American Bar Association, which is comprised of primarily criminal-minded individuals who are hell-bent on throwing their clients under the bus in order to preserve the unconstitutional tenets of that particular organization. I'm going to give y'all an example. There are hidden tenets associated with the American Bar Association or the North Carolina Bar Association or any other association for that matter dealing with the bar. And that is this, y'all. Let's say, let me use somebody that came through in the chat. Okay, let's say Boss Boy 8. Let's say I was an attorney and Boss Boy 8 was accused of committing an offense. I realize that there's certain information that can get Boss Boy 8 off on account of a technicality or just an abuse of, let's say, police practice. So in order to do that, though, I'm going to have to throw one of my associates under the bus. Now, what the Bar Association, the tenets of the Bar Association says, in which they do not tell us, is that I can't do that because I have to protect those under the Bar Association, right? So if throwing a client under the bus is to protect them, that is what they would have me do. And because I knew that, there is no freaking way that I would ever become a part of any bar association that's comprised of people who think and feel that way. Because I'm all about freedom, justice, and equality. We have a conflict of freaking interest. That is why I litigate cases on my own behalf, because by doing so, I am not under any freaking rules or regulations that someone else claims that I should be governed by. You know, there was a guy that was incarcerated in federal prison many years ago. His name was Charles Lester Van Ness, aka Midnight. Midnight, if you ever see this video, brother, just know that I still think about you, man. And it's been an honor to help you out, brother. But look, Van Ness was in prison, federal prison no less, for over 20 years of his life for a crime that he did not commit, a crime that he was not even convicted of, y'all. Now, keep in mind, this man had attorneys at law take his case. They couldn't get him out. He had these incompetent, what they call jailhouse lawyers, couldn't do nothing. But the moment I came along and took an interest in that man's case, and he decided to allow me to assist him, y'all know Van Ness got out of prison in under 1 year after I took that case, after I decided to assist him in that matter. But I will give it to Van Ness, though, because he did play a part in his own defense. And not only that, by him listening to me, it was not just was primarily me, but also I got to give what they call props or recognition to members of the Federal Public Defender's Office, who Judge Lambert immediately reopened that man's case after 20-something years based upon a little paragraph that Van Ness wrote in conjunction with the advice that I gave. Judge Lambert reopened that case, y'all, instantly and instructed members of the Federal Public Defender's Office to look into it. That was a real judge at that time. I ain't gonna lie. See, some judges are about that life, about ensuring freedom, justice, and equality is issued. But here's the thing. Me knowing what I know based upon what I've been through, I told Van Ness to get a copy of all his legal documents, which he did. And the purpose for me doing that was that because if you don't get your legal documents and you end up making a complaint, and all y'all take heed to what I'm about to tell you, if the complaint that you're making can be utilized to bring down somebody in civil service, they will go into the record and doctor those particular documents. They will get rid of specific documents that can be led back to them doing what it is you accuse them of having done, in which they should never have done, to cover themselves up, to cover one of their colleagues up. But if you get that information before you file anything, if they do doctor a document, you have proof that that document was doctored because you received it first. You see? That's how you get them. So if Van Ness received it first, and let's say they came back and said, oh no, This document says this. Van Ness can say, well, look, I got the document before you. And this is what the document says. So due to the fact you got it after me, obviously you doctored that particular instrument, which means that that particular civil servant can be held in contempt of court, right? Because that'll be associated with the act of obstruction of justice. We got to think, y'all. We can't always assume that everybody in civil service is fair and balanced, because I can assure you all that they are definitely not. But anyway, Van Ness ended up getting out of prison, y'all. I don't know how the brother's been doing since then, but he's been out for probably like 10 years. But he used to tell me this, y'all. He said before he met me, he never seen light at the end of the tunnel. He said, but after he met me, every day he spoke to me. Every day, the light at the end of the tunnel became brighter and brighter and brighter. So no, one does not have to go to law school to help an individual get justice in the court of law. That's something that they want us to believe. That's not true. And if a man has a right to represent his or herself, right, under the case of Ferretta versus California, how can they say, and when I say they, those in civil service say, that a man does not have a right to assign someone such as myself to represent his or her interests in a court of law? You see, we have to start thinking for ourselves. We can't always accept what these judges say, because oftentimes what they say and do is not right. And in order to hold them accountable, we need to put our foot down. We need to go a different path. And how we do that, y'all, for those of you who do not know, we invoke the right of jury nullification in a court of law. And that right gives us the authority to disregard any law, any judge's instructions, any evidence, whether they be video or audio recordings, anything, for any reason, if we feel that the law that is being enforced, that they want us to apply to a specific case, is unconstitutional. That is how we as individuals, we as civilians, uphold the Constitution. And in the process of upholding the Constitution, we're holding those accountable for violating the Constitution by deciding to not issue true bills of indictments for those of us who are called to serve as grand jurors. We hold them accountable through declining to convict someone for a freaking offense that we know to be unconstitutional. But how would we know that if we have no knowledge of law and politics, though, right? You see, that is why it is so important that we learn about law and politics, because without it, we're in the blind. I mean, a police officer does something that they shouldn't do. We know it's not right, but we don't have no knowledge of law to the extent that we can utilize to put them in their freaking place, or to justify our actions against them. And what I mean by that, y'all, we too have a right to resist an unlawful arrest. And we have a right to resist an unlawful arrest with physical and or deadly force. That's coming from the judges in the Supreme Court in the case of United States versus the Reed and the John Badell case. We have that freedom, but many of us are unfamiliar with those specific judicial decisions that gives us, or that acknowledges, that authority that we have over those civil servants in public office. See, I know about those freedoms. That's why certain things that I've done as it relates to encounters that I have with law enforcement personnel, it worked for me, y'all. And yeah, of course, you can see that I'm a freaking African-American man. So for those of you African-American people who believe that the Constitution does not apply to you by virtue of your skin color, I can assure you that you're absolutely incorrect. And if you continue to believe in that nonsense, the law will never have the effect upon your person as it was initially designed to have. You see, if you don't believe in something, you can never utilize the very thing that you do not believe exists. But I come on these apps, y'all, to talk about law and politics because I was able to study, right? I mean, taxpayer dollars funded my legal research, my education in that regard. So, being that that is the case, I know that many of you didn't have time to study hundreds upon hundreds of judicial decisions as I have over a 20-year period. So, I feel that it is my duty and responsibility to give back to you all based upon what you have given to me. And so, I educate you all based upon what the law really says so you can make the decision or determination on what is right and really wrong. Now, I'm going to read off a few more cases, right, to clarify the issue that I've been speaking about here today. All right. For those of you who are unfamiliar, the right to keep and bear arms is a fundamental right or natural right, fundamental or natural right. That is because it predated the Constitution. It's a human right for us to be in the position to protect ourselves. And of course, we utilize weaponry to protect ourselves with when we're faced with an opponent that may be bigger and stronger than us or faster. Okay. Now, in support of the right to keep and bear arms being a fundamental right, let me direct your attention to the case of McDonald versus City of Chicago. I read that case earlier, so I won't go through the citations again, but I will say that on page 768 to that specific judicial decision, Associate Justice Alito Jr. said on behalf of the majority that, and I quote, the right to keep and bear arms was considered no less fundamental by those who drafted and ratified the Bill of Rights, end quote. Okay, so now we have legal authority that specifically supports the argument that I just made that the right to keep and bear arms is a fundamental right. Okay, now what does a judge say about fundamental rights being encroached upon? I found this case to really hit home in that particular area. And that case is known as West Virginia State Board of Education versus Barnett. Citation number 319 US 624 87 LED 1628 63 SCT 1178 1943. And that case was written by Associate Justice Robert Howout Jackson. On page 638 to that specific judicial decision, Judge Jackson said, and I quote, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections, end quote. Okay. Now, that specific decision specifically says that fundamental rights may not be submitted to vote because they depend on the outcome of no elections. Now, what happens, if you all recall, when I was telling you about how laws were enacted? Okay? Before a law is enacted, right, what does members of a federal or state legislature do? I'm going to tell you all what they do. They vote on whether a specific bill should become law, which means that the National Firearms Act, the Gun Control Act, all of these acts were put up to a vote in the United States Congress. The Felony Firearms Act of North Carolina was put up to a vote by the General Assembly of this particular state. Put up for a vote. to determine if the right of the people to keep and bear arms should be restricted under certain circumstances, in total violation of the Second Amendment to the Bill of Rights. Which means that every act of gun control by virtue of the two decisions that I just read to you all is unconstitutional. No questions asked. Real simple when you put it in that proper perspective. And I'm pretty sure, like I said earlier, many of you didn't know about these particular decisions, especially the Barnett case. I mean, of course, we done heard about McDonald versus City of Chicago more so than we all have heard about West Virginia State Board of Education versus Barnett. But that's just a fact, y'all. The Second Amendment right to keep and bear arms is a fundamental right. The judges of the Supreme Court, who people give so much emphasis to the decisions they make, specifically said that fundamental rights may not be submitted to vote because they depend on the outcome of no elections. That means that every act of gun control that was put up to a vote prior to it becoming law is unconstitutional, which means that it's non-enforceable. And because it is non-enforceable and has been since its conception, means that every individual here in the United States of America has the right to keep and bear arms, and that every individual who has been penalized on account of exercising that freedom are currently incarcerated for crimes that they never committed, for offenses that they should have never been in prison for. Oh, and in sticking with the District of Columbia versus Heller case, doesn't end there because those judges actually substantiates or supports what the judges in the Barnett decision came to the conclusion of. Or more specifically, the judges in the McDonald decision, which correlates with the Barnett decision. Now, what I mean by that, on page 592 to the District of Columbia versus Heller case, Justice Antonin Scalia, and right for the majority, said on page 592 that, and I quote, the Second Amendment codified a pre-existing right, end quote. So we also know that the Second Amendment is a pre-existing right because, like I said, it predated the Constitution. So it doesn't rely upon the Constitution for its existence. That is why when people say that we have a constitutional right to bear arms, that is incorrect. We have a civil right to keep and bear arms because that right is specifically under the Bill of Rights, which is specifically reserved to the people. And we find that to be true under Amendments 9 and 10 to the Bill of Rights. Okay. Now, what does the judges say about the right to bear arms being a pre-existing right? Well, we find that in the case of United States versus Verdugo Orquidez, citation number 494, U.S. 259, 108 LED 2D 222 or 222, 110 SCT 1056, 1990. Now, that particular decision was written by Associate Justice William J. Brennan Jr., who was joined by Thurgood Marshall. And they cited the United States Constitution as that relates to Amendment 9 to the Bill of Rights. And on page 288 to that specific decision, those two judges said, and I quote, thus, the framers of the Bill of Rights did not purport to create rights. Rather, they designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing, end quote. Okay, so the Second Amendment right is a pre-existing right, right? We know that. District of Columbia versus Heller. And we also know from the Orquidez decision that Those in civil service or in governmental positions have no authority under the Constitution to infringe upon rights and liberties that were presumed to be pre-existing. So because the Second Amendment is presumed to be a pre-existing right, that means that every act of gun control, again, as I stated earlier, is unconstitutional, my people. That is why I urge every last one of you, if you're ever called to serve as a grand juror or a pettit juror in a criminal case, if anyone is charged in the federal court system with the offense of possession of a firearm in commerce after felony conviction, it should be no question as to what your decision should be. And that decision, according to the judicial decisions in which I have read, should be not guilty all the way. I mean, there's really nothing to think about here. I mean, everybody has a right to keep and bear arms under the Second Amendment. That's a pre-existing right. It is a fundamental right. And fundamental rights cannot be put up to a vote because they depend on the outcome of no elections. Pre-existing rights cannot be infringed upon by those in civil service, which is exactly what they did when they created the law. So in order to put things back into the proper perspective, we have to say not guilty, y'all. We have to, for those of us who feel that we have no choice, we have to invoke the right of jury nullification to ensure that justice is really served. That is the only way to hold those in civil service accountable for encroaching upon the very freedoms that we have under the Declaration of Independence, Bill of Rights, Constitution for the United States of America, to include the Universal Declaration of Human Rights. But it doesn't end there, y'all. Of course, I have more freaking judicial decisions to support that particular aspect of the argument that I'm making. Now check this out. Lucas versus 44 General Assembly of the State of Colorado. Citation number 377, US 713 12 LED 2D 632 84 SCT 1472 1964. This particular decision was written by Chief Justice Earl Warren. And on pages 736 through 37, to that specific judicial decision, Justice Warren said, on behalf of the majority, that, and I quote, a citizen's constitutional rights can hardly be infringed simply because a majority of the people choose that it be, end quote. You see, now the Second Amendment has also been declared a constitutional right, even though that's not technically the case, but that is how people perceive it to be. So we can surmise from this particular decision that the right to keep and bear arms cannot be infringed simply because a majority of the people choose that it be. So just because the majority of people in Congress chose to enact legislation designed to restrict one's access to firearms through gun control doesn't make it right. As a matter of fact, per that decision, it makes it completely unconstitutional. Completely, no questions asked. And because every act of gun control is unconstitutional, y'all, you have to understand that every unconstitutional act, whether that be from a judicial decision, a regulation, policy, rule, or statutory provision, it's non-enforceable, meaning we don't have to enforce any act instituted by members of Congress or any other state legislator, governor, president, attorney general, that is unconstitutional, y'all. We don't have to accept that. And the authority for that particular argument is found in the case of Robinson versus Baldwin, a citation number 165, US 275, 41 LED 715, 17 SCT 326, 1897. And that decision was written by Associate Justice John Marshall Harlan. On page 297 to that specific decision, Even though this is a dissenting opinion, it holds weight because that decision correlates with the majority opinion rendered in the case of Marbury versus Madison. Okay? Now, what Judge Marshall Harlan says on page 297 is that, and I quote, in this country, the will of the people, as expressed in the fundamental law, must be the will of courts and legislators. No court is bound to enforce, nor is anyone legally bound to obey an act of Congress inconsistent with the Constitution, end quote. You see, the fact of the matter is government was designed, or let me take that back, governmental institutions were designed to protect the rights of each and every last one of us. So when the Constitution was interpreted through years of writing and going back and forth, it specifically said that it is a government of the people, by the people, for the people, right? Which means that we are in control of those in civil service. So when we hear these First Amendment auditors here on YouTube and elsewhere talking about how those police officers work for them, that is absolutely correct. Because we're the ones who pay their salary. If it wasn't for us, people would not have been elected or appointed to where they would be in a position of privileged authority that they currently have, in which we have given. But unfortunately, so many civil servants forget where they come from. But yeah, we don't have to obey any law that's inconsistent with the Constitution, y'all. So when we see that the right to keep and bear arms shall not be infringed, that means that we don't have to agree with any laws. As a matter of fact, we should not do that. So if a man, let's say brothers and sisters in Chicago, I'm gonna give you all an example, has a Glock with the sear, aka switch on it, and they get caught with it, and they get charged with having a machine gun. Well, having that gun is not a crime. It is actually a right under the Second Amendment. And because it is a right, any law that restricts that particular freedom is unconstitutional, which means that we should never indict nor convict, especially convict, because what you all may not know is that prosecuting attorneys have a tendency of failing to have members of society issue a true bill of indictment. And what happens is, which they do not tell us, is that these same prosecuting attorneys will take their case to other members of society who have been called to serve as grand jurors and seek an indictment. Those people say, no true bill of indictment. So they'll go seek an indictment from other people. So eventually they come back with an indictment, right? So when a person decides to go to trial, the jurors already have it in their head that, okay, since they have been indicted, then perhaps they are guilty. But what those jurors don't know is that the prosecuting attorney has sought to have this particular individual or individuals indicted on various occasions. See, they don't tell people that, because if they did tell people that, it'll put in our mind's eye, hold up, if people have declined to issue a true bill of indictment on 4 separate occasions, that entails that they didn't really have anything on this person. So how did they get an indictment this time? Did they doctor information? Did they abuse evidence? And it gets us to thinking, right? But if we don't know about that, we're not thinking about it. And they utilize their ignorance to compel us through manipulation into convicting people, because they know that when we help them convict people for essentially exercising their freedoms, it puts them in a position to encroach upon the freedoms that we have also. And that's just what happens under equal protection of the law, my people. Now, I told you all that a conviction for the possession of a firearm by a felon is unconstitutional, and it shouldn't. Nobody should be in prison for that, right? I told you all that. But you know, the thing about me, unlike other YouTubers, I like to support the arguments that I make or the contentions that I make, the statements that I make with actual legal authority. And when I utilize legal authority, I'm actually quoting exactly what these judges have said about the matter at hand, to where there can be no misconception on what is being said and what should be done. With that being said, let me direct your attention to the case of Ex parte Seabold, citation number 100 US 371, 25 LED 717 1880. Now, don't let the year of 1880 fool you. This is still a good decision to this very day, what they like to consider good law. But I don't consider a judge's opinion law, because the Constitution under under Article 1 specifically says that members of Congress associated with the House of Representatives and the United States House of Senate are the only individuals who can make law in this country. And that also goes for every other state legislator based upon a state constitution, which mirrors, in that respect, the federal or national constitution. But Ex parte Seabold was written by Associate Justice Joseph P. Bradley. And on behalf of the majority of the judges who heard that case at that specific moment in time, Judge Bradley said, and I quote, "An unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment," end quote. Wow, that says a lot, doesn't it? Now, I just proved that every act of gun control is unconstitutional because legislators do not have the authority to make laws restricting our access to firearms or armament, for that matter. It doesn't matter if it's a firearm, grenade launcher, it doesn't freaking matter. But they want us to feel that it matters because they prey on people's ignorance and emotions. Not mine, though. But by law, it doesn't matter. So everybody that's in prison right now as I speak for simply carrying a gun, they didn't commit a crime with the gun. They didn't do nothing with the gun. They just had a gun on their person or around their person. That's why they bring up this constructive possession bull crap that makes no sense. They're just in there for exercising the Second Amendment liberty to keep and bear arms under the Bill of Rights, y'all. The vast majority of people that goes back to prison for having a gun is only there because they chose to exercise a specific civil right that they, like everyone else, has the right to exercise. And the sad thing is, so many people have taken guilty pleas, essentially saying that the exercise of a civil right is a criminal violation. You see how people have been manipulated to the degree to where they feel compelled to do something that they generally wouldn't do, that they truly don't even believe in. We don't, for the most part, believe in that either, y'all. And I know a lot of people say that they don't like firearms. Well, I don't want to carry no firearm. They're dangerous. Nobody should have them. But yet the moment they are encountered with an individual hell-bent on harming them, the first thing that these particular individuals do is call the freaking police for aid or assistance. And they call law enforcement personnel because they know that law enforcement personnel does what, y'all? Well, shoot, let me break it to you. They carry firearms. Almost 4 years ago, I was shot by an unknown assailant without provocation outside of my mother's former residence, y'all. Now, I'm a working man, for those of you who want to know. I worked at an establishment known as Kickback Jacks. I was what they considered a floater, because not only did I help out at the primary location, but I also helped out at secondary locations as well. And on that particular day, I worked at the primary location. I went to a secondary location, and I went back to the primary location to help my friends close out. But it so happens that day when I got home from the secondary location and took a shower and I was heading back out, my mother told me this, y'all. She said, Okang, there were some suspicious people outside the house today. And so I opened the door to get a better look at them. As she opened the door, well, this is what she said. As I opened the door, Okang, they saw me. So it was a guy with dreads arguing with a female. And so when they saw my mother, according to my mother, they drove off real quick. So my mother found that to be odd due to the fact that her residence was shot up on how many times that? No, 5 occasions in the past. Okay, so she thought that was suspicious. So my mother's advice to me was, which I didn't fully listen to, Okan, wear your body armor and carry your guns when you leave out the house. Now, I had the body armor in the trunk of the car. I didn't have it on me. But I did have one gun because I left one gun at home just in case she needed it, even though she wasn't too familiar with firearms at that time. But I went to work, but I noticed as I was leaving that there was a car on the road that typically I've never seen, but it shouldn't have been there. I never seen it before. So that struck me as kind of odd, but not to the point to where I became fearful of my life. So I went to work. When I got there at the establishment, my colleagues were walking out. So they were able to close up quickly with just them two there. So I ended up going home. Now, as I got home, I noticed that headlights mysteriously appeared from behind me from a car out of nowhere. So whoever was following me, they had their lights off until they turned them on. You know, that's suspicious, right? So what I do, I pull up on the opposite side of the road to my mother's residence. And I get out the car with my firearm in hand. And at that time, y'all, I had a Remington 1858 single action revolver outfitted with a conversion cylinder chambered in 45 Colt cowboy action loads, of course. But these were the high powered cowboy action loads. Okay. And cowboy action loads because technically that specific firearm under federal law and the laws of North Carolina is considered to be what they call an antique firearm, which is legally defined as any firearm manufactured prior to the year of 1899 or any replica thereof, if the replica doesn't take conventional centerfire or fixed ammunition. And many people have the tendency of questioning me about that. Well, how can you have a gun if it has fixed ammunition? It's considered a firearm. It's not. I mean, but that's because many people don't understand law to the extent that I do. Now, what I told one guy, or a few guys actually, when you get a conversion cylinder to a replica of an original antique firearm, that conversion cylinder was manufactured prior to the year of 1899, which makes it an antique under federal and state law. Which means that if you put the drop-in conversion cylinder in the actual firearm, you're not reconfiguring anything. You're not changing the barrel. You're not changing the breech block. Anything about that firearm. It's just a drop-in cylinder. Cylinders that they had prior to the year of 1899. Okay? So that makes that particular conversion cylinder legal because it is associated with the antique firearm in which federal and state law profess or declares to be lawful. And so when we say fixed or conventional centerfire fixed ammunition, we have to understand that when replicas of antique firearms were initially manufactured, many people in these firearm companies outfitted those specific handguns with, let's say, I've seen replicas of an original antique firearm chambered in 357 Magnum. Now we know 357 Magnum, if I'm not mistaken, came out in the year of what it was, 1941. So we know that that particular ammunition is not considered antique ammunition. Hence, it's considered ammunition under federal and state law, right? Okay, so we know that if a person has a replica of an antique firearm chambered in that particular ammunition, that they can be according to how they got it written, prosecuted. All right. Um, what other calibers have I seen? 44 Magnum. We know 44 Magnum came out after 1941. Okay, if I'm not mistaken, it came out after the fact. So we know that that is not an antique round. That's where you get conventional at. See, conventional ammunition is ammunition that's readily available, right? Like you can get this ammunition from anywhere. I'm gonna tell you all something. You can't get 45 Colt Cowboy action loads from anywhere. I mean, there's certain companies manufacture that. I mean, you can't go in Walmart right now and say, "Hey, give me some 45 Lone Colt Cowboy action ammunition." Man, I don't got it, man. So it's not conventional. It's not readily available. Like you can't get it anywhere. And even if you could, it's still considered an antique round because when you look at the case of United States versus Royal out of the United States Court of Appeals for the Fourth Circuit, who adopted the Seventh Circuit United States Court of Appeals decision, and speaking about that matter. And they say that if ammunition was specifically designed to be fired in a specific firearm, that ammunition is not legally defined as ammunition. Hence, one cannot be charged with the possession of ammunition by a felon. Okay? This is something that you all have to understand. So when you get a replica of an antique firearm, such as the Remington 1858, in which I own, you have to make sure that the one that you have is not, it's not chambered in modern day ammunition or ammunition that was designed after the year of 1898. Now, another thing, when you get, let's say, the 1873 Cattleman. Now, the original was chambered in 45 Colt as well, right? So, yeah, you can have a replica of that that's chambered in that ammunition because it is a replica of the original firearm. But if you get one chambered in 357, that's when they say that it becomes a firearm all of a sudden. Now, I don't, oh, shoot. This live about to end, y'all. I'll holler at y'all later. Have a good day. Okay, I take that back, y'all. It was a false alarm. Had to get my little charger out, but I thought the live stream was about to end, but fortunately it's not. But anyway, as I was saying, original antique firearms that have been remade to chamber ammunition that was manufactured after the year of 1898 have been declared to be firearms. Any firearm that's chambered in ammunition that was manufactured prior to the year of 1899 is considered an antique firearm, which is not legally classified as a firearm. So if you ever get a firearm, just make sure that it's chambered in an antique round. And that's any round that's manufactured prior to the year of 1899, as I indicated earlier, such as, let's say, 38 Special. That was manufactured in the year of 1898. So that's technically an antique round. You got 38 Lone Colt, manufactured prior to the year of 1899, to include 455, Webley, 45 Lone Colt, of course, 32 Smith & Wesson, 32 Smith & Wesson Long, 22 Long Rifle, 22 short, 22 long. Those rounds were manufactured prior to that year. Unfortunately, um, I haven't seen any 22 handguns or 22 caliber handguns that were manufactured prior to the year of 1899 still in circulation today. So it'll definitely be hard for one to find that specific weapon who has obtained a prior felony or certain misdemeanor conviction, who would be what they would consider in legal possession of a specific firearm. But yeah, but that's the case though. So that's the weapon that I used. And keep in mind, this particular individual, he had what the detectives told me based upon the casings that they found, a 9mm semi-automatic handgun. Now we know that 9mm have a capacity for 10 rounds or more, whereas the Remington 1858 only chambered a maximum of 6 rounds in the cylinder. Okay. Now I only have 5 rounds in the cylinder because the word is, or rule of thumb is, that if you have one of those firearms, due to the fact that they have no internal or external safety, it was always safe to have the hammer rested or resting on an empty chamber. So I did that. So when this idiot started shooting at me for no legitimate reason at all, without provocation, I fired back. And in so doing, I was outgunned to a degree, y'all. I mean, let's be realistic. I mean, this man had a 9mm. I don't know what type of firearm he had, but most people have Glocks, right? So let's assume he had a Glock, and let's assume that he had a 17-round magazine or a freaking 100-round drum, 50-round drum. Who the heck knows? But I was definitely outgunned. But what I had in my favor, for those of you who are wondering, for those of you who may be thinking about getting an antique firearm for self-defense purposes, 45 Colt is a big round, so it has more knockdown power than a 9mm round would have, and it's louder. So when I started shooting back at this guy in an act of self-defense and actually striking his vehicle, getting close to hitting him, that man took off. He took off, y'all. And so when the idiot made a left down the street, I had that fool in my sights. And I'm going to be honest. I had the doggone sights, front sight resting on his temple. And I pulled the trigger and heard that click. And the only thing I can think about when I heard it was I loaded 5 and not 6. So from that point on, I started putting 6 rounds in those antique firearms. 6. Because in a gunfight, y'all, the more rounds we have, the better off we're going to be. Let's just be freaking realistic. But I was outgunned though. And my point is, for those of you who have been convicted of felony or certain misdemeanor offenses in which those in civil service, to include other civilians, claim that you should no longer be allowed to have your to have a gun for protection, if you do get an antique firearm, you're going to be at a disadvantage to some extent or another. Now, they do have double action revolvers that are considered antique firearms. Primarily, the one that I'm looking for is the 1898 New Service Colt. I definitely want one of those. They actually have a couple at one of the gun stores that I shop at, but it's like $1,700. Now, I got the money to buy it, but I'm not going to spend that money on a gun due to the fact that I have 25 weapons right now. But I definitely want that though. I mean, I think that'd be a good, decent gun for the purpose of self-defense. Plus a Chamberlain 45 Colt. I also want a judge too, or a governor. I eventually get one or the other at some future state. But yeah, y'all, the right to keep and bear arms is real, and that is a freedom that shall not be infringed. I don't give a crap how we feel about somebody. I don't give a crap what somebody has done in the past or what they accuse somebody of doing in the past, because we also have to understand that many people that are currently incarcerated for the commission of a felony offense, whether that offense is violent or nonviolent, are there for crimes that they did not commit. There are innocent men and women currently in prison right now as I speak. Now, I don't know if you all know about Daryl Hunt, but Daryl Hunt was a North Carolina citizen. And for those of you who don't know, you can actually look the name up, and I'm pretty sure something will come up on Google. But Daryl Hunt was accused of killing and raping a Caucasian woman. I think it was what, back in the 80s? Back in the 80s, if I'm not mistaken. And during the course of the trial, based upon witnesses' um, statements during these documentaries that were created on account of Daryl Hunt, they claimed that the evidence was just so airtight. Like they had all the evidence that was just so airtight. But yet, over 20 years later, when DNA analysis became more prevalent in the judicial system, it was determined that Daryl Hunt did not rape that woman. And if he didn't rape that woman, then of course he sure as heck didn't kill her. You see what I'm saying? But let's say Daryl Hunt got out on parole like 8 years after the fact and he got a gun. He would have went back to prison because people would have been under the erroneous presumption that he was in possession of a firearm by a felon. When the fact of the matter is the brother was innocent all along. That is why we cannot base our determination on how a person should be treated on account of what somebody claims that an individual has done in the past, y'all. We can't discriminate against people because that is a violation of one's human right. What do y'all think defamation of character comes from? You saying things about people that are not true, discriminating against people. There are laws against that. People get sued on account of that. But just because they don't enforce those specific rights when it comes to this specific freaking idiotic unconstitutional law does not mean that the law is not unconstitutional. It does not mean that it should be enforced by us. Now, if they want to enforce it, we have the last say so as the American constituency in the matter at hand. People just don't go to prison. Prosecuting attorneys just don't put people in prison. They got to go through us first. We have to sign off on that nonsense. And I'm simply saying, my people, that we have to stop doing that. We have to. And in order to stop doing that, you all have to become familiar with law and politics, not based upon what they have led us to believe through propaganda. I'm talking about actual law, like what I read to you today through quoting what these judges said, that specifically supports or substantiate what it is that I've told you all today thus far. We have to be better, my people. And in order to get better, we have to do what is necessary. And I know many of us don't want to invoke the right of revolution, which may be required in order to put things back into the appropriate perspective. I don't want to have to hurt nobody, but at the same time, I'm not going to allow civil servants or anyone else to encroach upon the very freedoms that I have in which I put them in public office to protect and defend. If they're not willing to protect and defend the freedoms that I have under the supreme law of the land, then I am going to be compelled under paragraph 2 to the Declaration of Independence to do that for them. And I don't rely upon anyone to help me. I'm in a position to take them it is down myself. I don't care what title they have. I don't care if somebody says, "Oh, I'm a United States Marine. I'm a Green Beret, Special Forces." Man, that stuff don't mean nothing to me when it comes to protecting and defending the freedoms that we have under the Constitution that we talk about so much. Matter of fact, people in the armed forces, they learn from individuals like me. Now, for many of you, it may not seem like I'm much, right? I mean, the way that I dress, little white shades on, and I got the shades on because this ring light is a little bright. By the way, for those of you who are wondering why I have shades on in the residence that I reside in, but that is the reason why. We have to be ready, people. And for all of you civil service and public office, you don't know me. I'm letting you know that now. I don't give a crap about what you heard about me. I don't give a crap about what you think about me. But I am not the one that you think that I am or was back in the day. Let that sink in for a minute. But while that sinks in, I'm going to end this live stream, y'all. I know it's like 2 hours and 4 minutes and 41 seconds right now as I speak, but I hope that some of you got something out of what it is that I said tonight, because, like I said, it is my duty and responsibility as a fellow human being and citizen of America to educate everyone on the civil, constitutional, human rights that we have, protected under the Declaration of Independence, Bill of Rights, Constitution for the United States of America, and the Universal Declaration of Human Rights. Because if we don't know about those freedoms, we will never be in a viable position to hold those accountable when they choose, as they have done on many occasions in the past and will continue to do so today and in the future, unless we stop them through invoking our right to either revolution or jury nullification. And the next live stream I do, I'm a piggyback off of this live stream by going into the right of jury nullification and the right of revolution, and how those two freedoms are required to be invoked by us to hold those in civil service accountable by ensuring that they do what we put them in those positions of public trust to do. With that being said, I hope you all have a nice day or night, depending on where you are in the world. And before I go, I'm going to see if there's any way that I can follow those of you who have came into the live stream. So yeah, y'all, I'm just about finished doing what I'm doing or saying what it is that I had to say thus far. But I really would like to okay, pin message. See, this is what I don't like though. Because I know when I replay this live stream, I don't recall ever seeing the comments. So what I'm gonna do, I guess I'm gonna take a video of this particular live stream on my end, because I really would like to reach out to you all in person, just to show my appreciation to you all for coming through. Try this again. All right. Well, shoot, it's not even working. All right, so got top fans up here. Okay, Chloe Hayes, Boss Boy 8, Case and Sam Ace, 2310. Appreciate y'all. But if y'all here though, I want you all to hit me with a follow if you haven't already. Subscribe to the channel, y'all. And if there's anything that I've spoken about here today that you all may have questions with, if you all need additional insight with regards to what the law says about the issue or topics that I brought up today, feel free to send me a direct message. You can follow me on Facebook, Instagram, Bigo Live, fan base. Did I say TikTok or Instagram? Yeah, y'all just follow me, because I have a lot of freaking information that can be utilized by any one of you to put things into the proper perspective, to where you can not only be in a position to help yourselves if you're ever confronted with a specific issue, but you can also spread the word to other people that you may know. I'm pretty sure many of you have people that's incarcerated right now, right? For the offense of possession of a firearm by a felon, right? And those statutory provisions that I mentioned today are the legal authority that can be utilized to ensure that they are discharged promptly from imprisonment. But we have to play our part, people. We have to.